Good morning, students. Welcome back. Standard 9, Subject History, Chapter 6, Empowerment of Women and Other Weaker Sections, Module 3. Students, in the previous two modules, we have learned about women's participation in the freedom struggle as well as the various movements in which they had tried to improve the conditions, the living conditions. We learned about the Bhudan movement, the Latne Morcha, the Chipko movement, the anti-Iraq movement or the anti-liquor movement, and how when this was brought about in the UN had declared 1975 as the International Women's Year and started various projects and programs to bring about peace, development, and equality between men and women. There were many movements and many committees established in the state of Maharashtra too, where women came out and sorted out and brought about a struggle against issues like dowry, female feticide, and domestic abuse. We also learned about the different laws that were enacted for women in favor of women, like the Dowry Prohibition Act, the Maternity Benefit Act, and the right that were bestowed legally to a woman. Let us learn further. Awareness against the dowry tradition. In spite of bringing up a Dowry Prohibition Act, there were many incidents like woman burns to death as sari pallu catches fire while cooking. These were the highlighted headlines in those days. And woman slips into well while washing clothes, drowns and dies. These continued to be reported. Investigations revealed that it was not perchance, rather, these were all cases related to dowry. They were dowry related death cases. In the year 1990, the number of dowry deaths was 4,835. In the year 1993, it rose to 5,377. This brings us to the seriousness of the issue. There were many dowry related violences like physical torture of the wife, acid burns. The wife used to run away from her husband's house, unable to bear the torture any longer, or she would commit suicide. In the year 2013, within a span of 10 months, 4,470 women became victim to dowry related deaths. This brings us to a very important question. Why does dowry still exist? This still exists. The system of dowry still exists because of the perception that dowry has to be given as a tradition or it is a matter of social status. In spite of laws, there is lack of implementation of these laws. There is lack of education and awareness. There are discriminatory attitudes. There is lack of political will. And there is corruption and poverty. So, as the awareness is brought about in the society, we hope to bring about a positive improvement in the status of a married woman. Next, we learn about family courts 1984. Family courts were established to resolve conflicts arising out of differences within marriage and domestic problems, as well as issues such as alimony, single parenthood, separation, care of children, and ownership, which are all related to the family situation. These family courts gave priority to mutual understanding over witnesses and evidence, and the lawyers would counsel the couple to stay amicably and peacefully together. Emphasis is on resolving issues quickly but justly. There was a very famous trial which involved the case of alimony in the year 1985. A fixed amount paid to a married woman for her upkeep by the husband who has divorced her is called alimony. This happens after a divorce is finalized between the husband and the wife by the family court. In this case of Muhammad Ahmad Khan versus Shah Bano Begum, the Supreme Court gave the verdict that Shah Bano Begum had the right to alimony. However, religious organizations protested against the verdict. As a result, the Muslim Women's Act, that is, Protection of Rights on Divorce, was passed by Parliament. Next is the Sati Prevention Act of 1987. You all have learnt about the practice of sati in your previous standards. There was a act that was passed legally in the year 1987. This act prevents the practice of sati, forced burning, and burying alive of widows. Also, the people glorifying this practice or building temples and trust in the name of the sacrificed widow will be considered as a punishable offense. What was this act about? Why did this act come into existence in the year 1987? There was a case on 4th September 1987. If you look towards the right picture, you will see the picture of Roop Kanwar. She was a young woman who was married. She had to commit sati after her husband passed away. She did not do this of her own free will. Rather, she was forced or coerced by her community to do that. Committing sati, glorifying the practice were all illegal acts. The women activists and journalists Meena Menon, Geeta Seshu, Sujata Anandan, Anu Joseph, and Kalpana Sharma investigated this case. In 1988, the government passed the Sati Prevention Act with very stringent provisions. That is, it was made as a punishable offense. Next up is the Protection of Human Rights, 1993. In 1993, this law was enacted to prevent injustice to men and women. The National Human Rights Commission was also formed for this purpose. In some states, the State Human Rights Commission was also formed on the same lines. This law deals with collective oppression of women, the social conditions of divorced women, secure workplaces for women, and this act played an effective role in mitigating injustices to women. Thank you, students. Refer to the Word document attached below. Please go through your textbook for the lesson that has been covered so far. Revise well. Thank you. Have a nice day.